Thank you for tuning in to the Brach Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, we'll discuss a recent labor and employment alert from Brach Eichler titled, Suing an Employee for Unauthorized Computer Access Reaches a Dead End Under Federal Law. What should an employer do when an employee violates company policy by taking electronic files that the employee was not permitted to access? A recent Third Circuit decision answered the question by advising what an employer should not do: sue the employee under federal law for unlawful computer access. The Computer Fraud and Abuse Act of 1986, CFAA, creates a private cause of action and makes it a crime under federal law against a person who intentionally accesses a computer without authorization or exceeds authorized access, and thereby obtains computer information. 18 U.S.C. Section 1030A-2G. The downloading of electronic files from the company's computer system by an employee when the employee does not need those files to perform assigned job duties and violates company policy by doing so would seem to be the classic example of a CFAA violation. Providing access to company electronic systems is not meant to be an invitation for employees to fish around. Not so fast. The courts have generally been reluctant to treat workplace disputes as federal crimes, highlighted in a 2021 U.S. Supreme Court case, Buren v. United States, where that court noted that if the CFAA criminalizes every violation of a computer use policy, then millions of otherwise law-abiding citizens are criminals. Take the workplace. Employers commonly state that computers and electronic devices can be used only for business purposes. So on the government's reading of the statute, an employee who sends a personal email or reads the news using her work computer has violated the CFAA. Or consider the Internet. Many websites, services, and databases authorize a user's access only upon his agreement to follow specified terms of service. If the exceeds authorized access clause encompasses violations of circumstance-based access restrictions on employers' computers, it is difficult to see why it would not also encompass violations of such restrictions on website providers' computers. The Third Circuit in NRA Group, LCCV, Durenlo channeled this reluctance by concluding that the CFAA addresses only third-party hacking, not the more commonplace breach of workplace computer use policies. If the employee had permission to access the system, the CFAA is not violated even if the employee abuses that permission. What then may an employer do to protect its computer systems from wayward employees? A lot. Well-crafted workplace policies and written contracts with employees can afford an employer significant ammunition to respond to an employee who takes electronic files without permission. A word of caution. Some jurisdictions, including New Jersey and Massachusetts, sanction such employee theft in certain circumstances when the documents are used by the employee to vindicate certain employment rights. Whether an employee is protected under this doctrine is highly fact-specific, and at least in New Jersey, does not necessarily immunize the employee against criminal prosecution under state law. When confronted with employee electronic theft, an employer needs to carefully take into account all of these considerations. For more information about how your organization can protect its computer systems and electronic files, please contact Jay Sabin, Esquire, Member, Labor and Employment Practice at 917-596-8987 or jsabin@bracheichler.com. Don't forget to subscribe to our podcast on Spotify, Apple Podcasts, and YouTube. Follow us on LinkedIn and Facebook for updates on new episodes. For more information and resources, visit bracheichler.com. This is intended to provide general information, not legal advice. Please contact the authors if you need specific legal advice. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate, litigation, trusts and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property, and information technology, real estate tax appeals, tax and cannabis law.